So today, I would like to welcome our speaker, Hanan M. Isaacs. Hanan is a senior attorney with the Kingston Law Group. He is a mediator, arbitrator, and trial lawyer in the employment law field. Hanan's primary legal services are negotiation, dispute resolution, emphasizing the advocacy for employees. His clients are from federal, state, and local government employment, as well as the private sector. That's both the profit sector and the nonprofit sector. In addition, Hanan is a frequent lecturer, blog and article writer, and a multimedia presenter. A little about him: after graduating from Rutgers College, Hanan received a law degree with honors from the University of North Carolina Law School and a master's in American legal history from Rutgers University. TSG of Mercer County is always very honored to welcome Hanan Isaacs.
Thank you so much, Bill. I very much appreciate being here this morning and talking about law and employment. It's a very complex topic. There's so much of the work that we do as citizens, as workers, as employers, and it's always changing. I get a feed about every day from a national group that highlights and spotlights changes in law, cases, statutes, proposals, theories, and I find it interesting. That's why I do what I do. I also want to say I've been coming to PSG here in Mercer County for probably 5 years. I've presented a number of times. It's always a good time. David has become a good friend, along with Alex and some other people from this group. I'm glad to see Alex in the audience today. I also want to do a shout out to Shelby Buck, who's in the audience and helped me put together this presentation for today. So I want to start by saying, before I go into the slides, a couple new developments that have come to my attention. One is a bill in the New Jersey legislature. It's been proposed, and it's pretty controversial. We talk about from time to time the area of non-compete provisions, non-compete agreements. They're anti-competitive. The law of New Jersey says we don't like them, but we will honor them as long as it's done in a way that doesn't shock a judge's conscience. So you're not going to have, for example, an enforceable provision in an agreement between employer and employee that says you cannot compete with the employer for 10 years from the time you either quit or we let you go, or it's 250 miles from the barber shop that you were working at. Certain things become too much and they will not become enforced. So that was really the state of the law up until this bill came along. We don't know what will happen with it. But Assembly Bill 3715, which has been introduced in the legislature, basically changes the entire rules as they relate. It invalidates most non-compete agreements. Basically, and why is that? Because there are some states, some legislatures that say, we want to help the worker. And this is one that would absolutely shift the focus away from protecting the employer to allowing the employee to compete in the workplace. It's a problem. I mean, even if it's a 2-year provision in an agreement, you're sitting in the bleachers. You can't move. You can't act in the area that is your area of expertise. There's a proposal to say, if the employer is serious about that and wants to keep the employee away from their area of practice or work, compensate them. Pay them to sit out. And there are some companies that actually do that, but not many. Another highlight just came across my desk is that the New York State Legislature has passed, and the governor just signed into law, what they call a prohibition on no-fault absentee policies. What does that mean? It means there are some employers, I'm sure in New Jersey, there's no prohibition on it, who say, we're just going to add up how many days you've been out. We don't care whether it was because of a Family Medical Leave Act or bereavement or jury duty or your vacation time. If you hit a certain number of days off, we can discipline you up to and including discharge. New York State has just invalidated that. And I wonder whether New Jersey may do the same. So that means if you had a reason based on a statute, you cannot be terminated, even if the number of days added up totally with other reasons for absence puts you over some arbitrary number. So this is the kind of dynamic that we see in terms of public policy. I would say in a certain way, and I was thinking about this, what legislatures who are employee favorable, what they're doing is really in certain ways, instead of the employees waiting for a union to show up and create a powerful counterbalance to the employer. So it doesn't mean unions aren't still important, they are, but it's really the opposite problem, which is the number of workers who are covered by union agreements has reduced dramatically over the years. It was probably at a high point in this country of 35 to 40% of American workers getting union coverage. Now it's down to about 10%, which is, to me, pretty shocking. And perhaps in the pandemic environment, I think there's been something of a comeback. But in the absence of a union, people have to rely on a legislature to, quote unquote, do the right thing. And that's some of what we're seeing. Okay, so there's a fair amount of slides. I'm not going to overdo, I'm not going to read any of them, but I just want to introduce them. They will be available to you on the website, I think, after the program. I don't know how quickly after the program. So we're just going to pretty much zip through this best we can. So the first one, again, you don't have to read it now. This has to do with vaccines and a mandate in the environment and the workplace. I think it's possibly less important than it was, say, 2 years ago, but there were times that workers were fired because they refused to obey the employer mandate. The Supreme Court got involved, the US Supreme Court, because it said the federal government could not create a mandate and fire workers unless those workers were in a health type unit. And Governor Murphy, a year ago, signed an executive order that did exactly the same thing because he knew the US Supreme Court said you could go so far, no further, and he went to the limit of the law, saying if you're an essential worker in an essential function like a hospital and you refuse to agree, you can be removed. Another piece of that is if you have a religious qualm against vaccination, and there are some people who do. I've seen some things recently that say those folks should work from home. That's an accommodation that some courts have found acceptable. And these are not they're somewhat random in terms of the topics. This has to do with privacy and productivity. Some employers, not me, actually want to monitor productivity, and so they install certain software on employees' keyboards and computers. That's a major controversy. Here's a case we put on the right side, food for thought. There's a case that came out of Cleveland State University where the state university used software to scan a student's bedroom before an exam, I guess, to see if anybody else was in there, and cheating was going on, this type of thing. But there, again, there's a back and a forth. There's public policies that say employer has a right to know certain things, and the worker, or in this case, the student, has a right to privacy. So that's a balancing act. This pay equity is a huge topic. I've looked at this and talked about it a lot. There's issues about, may an employee talk to another employee about income, salary, against an employer saying, that's not for you to talk about. That one's pretty well settled at the federal level through federal policy that affects state workers, as well as state policy. New Jersey has a law that says if employees are talking about terms and conditions of employment, including compensation, the employer is not allowed to retaliate against them. But the issue of pay equity is a broader issue. It has to do with race and gender. People who gather statistics on these things will say certain people by gender, by race, are making more than others who are doing similar jobs. So there's a number of ways that state legislatures, again, who favor employee rights, are trying to attack that and clear that up. If there's an inequality for two people who are similarly situated but they look different, and there's no rational, reasonable explanation for the change, there's a statute in New Jersey and elsewhere that says that's prohibited, and it's actually the basis for a law claim. You also, in our state, have the right not to be asked on a job interview about your salary history, at least through the time that the decision is made. Do you get the job? Do you not? At that point, the employer is permitted to look into it. But now, New York has gone further, New York City actually, and saying to all employers, when you bid for people to come in and take a job, when you put out a release online or in a newspaper, we want you in good faith to say what the range of the salary is. Now, I saw one recently that said $60,000 to $500,000. Is that helpful? No. They're just trying to get around the law in that jurisdiction. But the purpose of it is if you're allowed to ask a prospective employee about their current salary, and you don't provide a range for what you're offering as a job, then isn't the job probably going to go to somebody who's on the lower end of that scale? As long as they can do the job. If somebody's making $60,000, somebody else comes in at $100,000, and they're relatively equal in skill sets, it's probably going to the lower salary. It's like a bid process, for a contractor. So New York City, effective really last year, but this rule is to address the gender pay gap and other wage disparities. This is a terrible problem in the employment area. So these are tools that legislatures, or in the case of New York, the City Council, seek to address these inherent problems of employment secrecy. Here's a follow-on topic, wage theft. That's really what it's called. There are a couple of ways in which an employer nationally and in New Jersey will classify somebody as being an independent contractor, even though they don't qualify. And there's whole ranges of employment. Truck drivers have been a massive issue of people who are over-the-road drivers. They only have one job, but they're treated as an independent contractor, even though they're really an employee. And this happens also in plenty of other sectors of society. And what happens there is once somebody complains about it, or this is found out by an agency of government, there can be very major penalties imposed. Also, wage theft would be calling somebody internally in your company a manager when they don't manage anybody, right? That happens more than you might think. So you're a manager, now you're getting a salary, but you're putting in a 50-hour week or a 60-hour week. What happens to your overtime pay? The employers who are doing this say, you're not entitled to overtime. You're an exempt employee, right? We call you a manager, even though you're doing the same work as the person over at the other desk, and maybe they're a manager too, but they're not actually managing. So this has become a major issue in the employment law area, and New Jersey punishes this type of behavior by significant penalties that now include criminalizing that. It also, the law extends the statute of limitations for minimum wage and overtime claims. It was 2 years, it's been expanded to 6 years. So this means even if you're not at that place anymore and it happened 4 years ago, you still can make the claim because maybe you had 1,000 hours that were undercompensated, either for minimum wage or overtime. Minimum wage, by the way, has been increasing in New Jersey and other states, and it's going to hit $15 an hour, I believe, after 2023. And the idea is for it to be a living wage. So if you did a 40-hour week at $15, you're now at $600 or $30,000 per year. For a lot of people, that makes a very, very big difference. So the next topic I have is unlawful interview questions. This comes up in these discussions all the time. This could be how many children do you have? How many children are you planning to have? What's your marital status? Tell us about your religious beliefs. Now, I'm going to say there is an exception in these rules to a religious organization, right? It could be a synagogue, a mosque, a church, whatever have you. They get something of a free pass on some of these things. They can say, what is your religion? Why? Because according to their belief system, if they want somebody who professes what they do, even if you're an accountant or a bookkeeper or a teacher, they can get away with that. I call it that, or they can do what's consistent with their principles. Pretty much everybody else shouldn't be asking those questions. So the point is, how do you deal with that? I like to be straightforward with it. I like people to ask themselves, if somebody's asking me an unlawful question on an interview, I would nicely say, I don't think that's a question that I should be answering. I don't think you're allowed to ask that, and just stop right there. Now the interview might be over, or the interviewer might say, oh, this person is a little feisty, which might be good for the company. You don't know how they'll react. But the question really becomes, do you want to work for a place that's going to ask that kind of thing before you even get the job? How are things going to be afterwards? So if you're truly in desperate need and you literally can't afford to say no, you know what? You're probably going to answer those unlawful questions. And there's nothing that I could say about that. I'm not going to judge a person for doing that. I'm just saying, if you have any other options, think about nicely speaking truth to power in that sense. Here's an area for question is criminal record. To what extent, if there's an online questionnaire before you even get in here, you have to fill these things out. People get nervous about that. And I suppose if you have no criminal background, like a conviction of a serious matter, we're not talking about parking tickets here, then you can truthfully answer and not really worry about it. But what if you have? I had a call yesterday from a former client who's a friend who said that she wants to go work for a bus company, but the interviewer said, fill out this criminal questionnaire. And in 1987, she had a conviction for possession of marijuana, which today is legal. But back then, that possession was illegal. And so she's going through the process of trying to get that off the record. Apparently, there's a law now in New Jersey where those old convictions get removed. You can apply for that, and there's an automatic expungement. It takes it off of your record. So if that works, she can get the bus driving job. Also, it's not just overt things like, tell me what it's like for you as a person of color or a different religion. But what about issues of and comments on your hairstyle, where you have a tattoo? that identifies you in some way. Those are also pointing towards discriminatory treatment, and they're not legal to ask about, and they're certainly not legal for the employer to make a hiring decision. So I'm urging people to be brave and stand up to those types of unlawful questions, and you'll make your decision when you make it. On an employee application online, there are things you could leave blank and just see how that goes. Maybe nothing happens. But some people don't like that. They feel like they have to do that. They really need that job. So I want to talk about whistleblower claims. This is where somebody, either inside a company or outside a company, generally speaking, you have a commitment to the public record. There's federal law that affects whistleblowing. I've heard of cases, I've never filed one, where a whistleblower that has to do with contracting to the military and pointing out some defect can actually get a pretty massive reward for that. But I want to talk more about the New Jersey, and I love the young woman with the whistle. That's a nice little illustration there. I want to talk specifically the New Jersey Whistleblower Act. A lot of detail here. Again, you'll see it when you look up the materials as part of PSG Mercer. But basically, this has to do with protecting people from retaliation when they stand up and report a problem. It could be a pollutant. It could be a theft within the organization. We have a case we're about to file of a high-level treasury person in a private company who basically let the employer know that there was an area within the company that some employees, some high-level employees, were stealing from the company. And they did an investigation. The investigation came out, we find nothing wrong, and oh, by the way, you're fired. And so there are things that go on in management that the employee doesn't understand. They would think, if I'm standing for the right principle, I'll be rewarded, not punished. That's the hope. Very often, it does not turn out that way. I had a case I litigated for a whistleblower in a pretty major setting involving an insurance company. And basically, management at first went along with this person's objections, and then quickly everything shifted. And he didn't know why. And the reason was because the company was, that portion of the company that he worked in was about to be sold. So this was a way of getting that off the books, so to speak, as well as getting the guy out of the way. And then everything else was just handled in the litigation setting. And ultimately, he had an excellent resolution to that, but at a big personal cost. And I remember Time Magazine, I think it was like 2003 or so, there was a person of the year was whistleblowers. And they had pictures of the whistleblowers from the IRS and somebody from Homeland Security. The person who reported that the 9/11 terrorists were going to a flight school and only asking for how to take off. And this person is like, wait a minute, that's a problem. And it never went anywhere inside the FBI until it was too late. But that's a very good example of whistleblowing. You're bringing it up. The public policy of New Jersey and many other jurisdictions tell us what you know. And by the way, importantly, you don't have to be right. You just have to have a good faith basis for the belief. Why is that? Because if you had to be right, that means if you know you turn out to be wrong, you're going to be fired, you're not going to take the chance. So that's what this is supporting. And it's basically saying, here are the remedies that you can count on through the law. But if you ask whistleblowers after the fact, after 1, 2, 3, 5, in my client's case, it was 12 years of litigation, would you do that again? The answer is mostly no, I would not. So this is a question about Americans with Disabilities Act. the New Jersey law against discrimination. Is an employer permitted to ask an applicant to answer medical questions, take a medical exam, or identify a disability? There is narrow area where somebody, if you're an astronaut, they're going to be asking you questions, or a prospective astronaut. If you're in a certain field that's so, sensitive, it could be a police officer, a firefighter. I'm quite sure the questions there are different from if you're going to be an internal accountant. But for the ones who are not in that specialized area, in terms of, let's say, a disability, if you come in and you're on crutches, or you have, you're blind, right, and you have a seeing eye dog, the employer is allowed to ask you whether you can do the job. Like, how is the obvious apparent problem? So it's sort of silly, but if a blind person applied to become a bus driver, there's going to be a problem. And you know that, and you can take that into consideration. So you can condition a job offer as an employer on certain medical answers or successfully passing an exam, but only if it's offered to everybody in the same way. You can't discriminate just because that person shows up with what you perceive to be a disability. I'm going to stop a second. Are there any questions?
Yeah, Hanan, we do have a couple of questions online, so let me start with those, and then Alex can jump in after that. The first one is, can an employer hiring in New Jersey ask what salary the candidate wants? Had that on an application form recently and had to pick from 10 preloaded salary choices.
I don't think that's right. I think there's a problem there, because essentially they're not asking history per se, but they're drilling down and saying, are you looking for 50 to 60,000, 60 to 70, 70 to 80? I'm sure that the New York City law would not allow that, because the burden is on the employer to say, this is the range. So I think that's not a proper question in salary history terms. I don't believe it is. Before you go, there's a question.
Just following up on that, I did one yesterday and I had the exact same question. It's online. Oh, sorry.
Can you come up here?
Sure. Didn't realize before online.
Why don't I ask you the second question while she's getting?
Okay.
I was just
She's ready.
following up on his question.
Okay,
his
go.
comment is that when you're on these online forms and they ask you what your desired salary, they're usually required. And if you don't put something in, you can't advance. So, they're there. Whether they're legal or not, I don't know. But I've rarely run across an online application that doesn't often ask that.
Yeah.
Some maybe not preloaded, but open-ended.
Right. I'm going to say it's not. I've not seen that issue. I'm hearing it. It makes sense, but it seems like it's pushing against the policy direction that we're seeing in New Jersey and other states. But I can't say it is illegal. I can say I have a question in my mind about it. And by the way, if you refuse to answer that and that knocks you out, I guess you're going to answer it if you want that job. That's the position that you're in.
Yeah, you basically can't finish the application unless you fill
Right.
it out as a required field.
Yeah. I'll tell you what I'll do. I'll look it up after and just post it on the website on PSG.
Okay, the other question online is, if I'm hired for a remote position by a company in another state, but I live in New Jersey, which state law applies?
Excellent question. My answer is going to be at 95% certainty. It's going to be the law of the state in which the employer exists. So if you're working for a New Hampshire company or North Dakota, the laws of that state will govern. However, if there's certain areas of law that if it's onerous, if it's like extreme, the New Jersey courts have extended our law against discrimination to cover certain things. But it's going to be case by case. I will say, for one thing, a very simple example, unemployment benefits are always going to be for the out-of-state employer. You're not coming here for that, even if you're residing here and working remotely. Anything else, Alan?
That's it. That's it online, so we've got out.
Can I ask the next question? First of all, Hanan, thank you so much for coming in today. This is extremely valuable for people, and not only they may not have this issue today, but you know what? This information is available, and they know where people to go to ask in the future. But here is my specific question. You provided a lot of topics. What really caught my eye is the non-compete issue, because that's a real issue. So let me set up an example. An electrician, licensed electrician, hasn't been working for a year and a half, and finally he finds an employer, they make an agreement, everything is great. The employer said, you know what, you need just to sign a few documents, and in a week, Monday, you can come in to start work. One of the legal documents says, you cannot work for anybody in a radius of 100 miles for the next 2 years. Should that individual sign on this? Because basically what you say, that's the only thing he knows how to do. He's an electrician. So basically you say, for 2 years, you sit at home and wait for 2 years to come up. How can, from the practical point of view, that electrician deal with this?
So this happens all the time. The craziest example, I read that in New York City, a number of the fast food chains were asking for signed non-competes for people who were making French fries, and like to protect the intellectual property of that job. It's silly. It doesn't make any sense. And I'll just say, a judge would not enforce that. The problem is getting to a judge. This is going to take a long time. Now, things happen. It's more likely the employer will do this than the employee. But if you've signed that agreement and then you see a lawyer who says, you know what, 100 miles is awfully big. Maybe it should have been 10 miles or 15. Go work and see what happens. If the employer is serious about it, they'll file an emergency application called an order to show cause and say there's irreparable harm unless the judge stops that person. And where do they get some assurance from? A lot of times the agreements themselves will say, you, the employee, and we, the employer, agree that a violation of this document, and particularly this provision, is irreparably harming. And if we prevail, we can also get attorney's fees for the employer from the employee because you put us to this trouble. I mean, that was the way it's been. It has been the way it's been for 150 years in New Jersey. If it's deemed a reasonable restriction, even though it's anti-competitive, it will be enforced. So the same issue that I said before as to responding to unlawful questions, signing potentially an unlawful non-compete agreement will at least get you in the door. And maybe you worry about it afterwards. It would take somebody who had a lot of power in that. So there was a time during COVID where people said, you can't get great employees. So the employee prospect comes in on the interview and says, I don't like that non-compete. The employer might say, don't worry about that. We're just going to X that out. But today, maybe they'll say, no, things are different. It's more of a buyer's market here from the employer standpoint. If you don't sign it, you're not working here. The prospect of fighting with that company, which is a whole lot bigger than you are, is going to take years and a lot of money. If they lose the initial emergent application, we know where the case is probably going to go. So essentially, maybe as the prospective employee, you could say, I'll test it, and if I win the first round, it's probably going away. But if you lose the first round, you're not going back in to that competition until the terms are complete. The courts also have the power in this state and in other places to change the things that are improper. So if 100 miles is offensive, they can strike that out and say, we're putting in 10 because we think that's reasonable. So 2 years, 10 miles. So that means if you're outside of the 10 miles, you can work. You know what I'm saying? So there's a give and a take.
My question is very specific. The electrician hasn't worked for a year and a half and very happy to get the job. And he said, oh, just sign here. Can he say, and would this be your advice? He say, I'm so happy to accept the job, but I'm not sure if I should sign this right now. I need to talk to a labor attorney to find out, is this a practical approach?
I think it's a fair approach. I don't know what the particular employer's point of view is about that. I mean, they have a lawyer, you can have a lawyer. I would say the more dollars are involved, the more expertise is involved, the better the chances that they will say, sure, do what you need to do on that. But then if the person comes in to see me, we're probably going to be back to the same issue. Now, one thing that's a little different, I could say, would you agree? Would you allow me to contact the employer, HR, their attorney, and find out how negotiable that particular provision might be? And that can happen. There's no reason to absolutely say never. But we don't know. We don't know till we try.
And then would it be practical for the employee to cross out the 2 years and fill in 6 months and sign? Is that acceptable?
I would not suggest that. I think they ought to talk about that and say, I'm willing to do everything, but that's too much for me.
Okay.
And I'll say, the more options that employee has or prospective employee, if you're looking at 2, 3, 4 positions, you're in a better space. But that becomes a hurdle. And I've had probably 3 of those that have gone to court, that we actually had to have a big fight about it. And these are cases where it's already been signed. So now it's in force, and they're coming to me saying, what do I do here? And I look at some of these and say, this is never going to get a judge's agreement. This is just wrongful. Or the employer did a wrong thing, and then the person left, and the employer says, don't forget the non-compete. So we then pushed back and said, if you enforce that, we will have to bring a suit to say what bad things the employer did. And we ended up resolving that case. It turned out well. But they're tough. The non-compete area is tough, which is why I started with this assembly bill saying, New Jersey, if this goes forward, and it's going to get a lot of pushback from industry, if this goes forward, it'll completely revolutionize the use and appropriateness of a non-compete agreement. You will have to justify it in the workplace to be able to enforce it. Do you have another question?
I did. I was just debating whether to say something about the comment about going to a lawyer before accepting the position. I mean, if you make yourself too difficult, they can rescind the offer. So it's just a real practicality of the situation.
Well, I hear what you're saying. Yeah. It's hard to.
If you're a very specialized, unique kind of situation where they really need you, then yeah, you probably have more power.
Right. That's what it's about. It's totally about how powerful you are in that negotiation. It's a negotiation at the end of the day. That's right. Exactly what it is.
I was going to make a comment about the disability thing here because, again, almost every online application asks you to fill out a form whether you're disabled or not. And Is that voluntary? It wasn't clear to me whether it was.
That's just a wrong question. I just think that is an improper
It's in
question.
all the online applications. They tell you that you don't have to say gender and that you don't have to declare whether you're a veteran. And then they make you sign a form about disability.
So here's what I have seen, and I've seen it in government employment, that you have to register your disability, which is kind of crazy. But it's not that they're discriminating. They're saying, and they even do it with existing workers every once in a while, tell us about this, that, because it's to cut down on surprise. But the issue should be, are you able to do the job? Period. If you need a reasonable accommodation, we have to talk about that too. There's another question from the audience.
Hi. Should be green. It's flashing.
Oh, sorry.
Okay. When you're speaking about a non-compete, I mean, that's a document that is issued upon entering an employer, that they're asking you to sign, that if you leave or you're asked to leave, that depending on what the terms of that non-compete, you're restricted to seek employment within those terms. But intellectual property is very different, right? If you've left a company and they have a policy that you don't have the right to take any of your creations or your developments, which is in essence their intellectual property, you would be in breach of that policy. But that's not a non-compete.
No, I was suggesting in my vignette
Yeah.
that if an employer goes to crazy lengths, like telling the French fry people to not disclose, formula for our great French fries, and not to compete with any other similar business, that goes too far. So there's some intellectual property protections that just are void. What if there was no intellectual property that you were using or knew about? What if it's information that's generally known? A fair employer agreement would read, we're restricting the definition of this to things that we've got copyrights, trademarks, other protections on, and that you learned here that you didn't know coming in, that you could use to disclose to a competitor. That's what they're legitimately trying to prevent.
Yes.
But you can't call it something that it isn't, any more than you can, as I said before, call somebody a manager who's really not. You could use the words, but it doesn't make it valid. So at some point, when you drill down, you're going to find out, were they just making it up, or is there something really there? Customer lists, is that a protectable interest? The employers will say that about everybody. You've been granted inside use of the following things. Sometimes it's just not true.
Right.
If it's real, and there are patents or other intellectual property protected things, it's fair to not allow those people to take that information and use it for a competitor.
So typically you would see non-competes for an employee that possesses a niche, competitive advantage towards the employer, that they wouldn't want you to be able to exploit that, to any competitor.
Well, here's the thing. It can be used properly. It can be used improperly. Like I say, if you call somebody this incredibly valuable person, and they're just basically creating widgets on an assembly line, it's misusing a tool. And it's really being used in some ways to discourage people and even frighten them against actually going and getting a job. But judges, when they get these cases, they know that, and they'll say, this is not a fair use of a non-compete. There has to be something that's protectable and valuable. Otherwise, it's being overstated and missold. That's the concern. And really, we have to be able to tell the difference.
Hanan, there's a couple of comments about the non-compete in the chat from Jerry. He said, my understanding is that non-compete is not really enforceable in New Jersey, but it scares the hiring manager off and will look at other candidates. And then his other comment was, although if they give you severance for the period of non-compete, it might be enforceable. So I guess he's bringing severance into the discussion.
Yeah. So I don't think it's accurate to say that they can't be enforced. The non-competes are non-enforceable. They are, if they're reasonable under the conditions that you have. Severance is very important, but it may or may not be tied to, without legislation or a company policy, the length of time that the non-compete says you sit out. Here's an interesting fact. I'm not allowed in the legal field to impose a non-compete on a lawyer who works for me. The entire field doesn't permit it because the Supreme Court of New Jersey said that, right? So if I hire a lawyer, they're going to take their knowledge, skill, information, and whatever I taught them, and they're going to leave. And they're going to be competing with me potentially. That's just the way it is. And this new statute, if it's actually passed into law, and I have some questions about it just by virtue of, kind of who's empowered in Trenton to do this or that. I'm not sure that's actually going to pass. But if it did, it would go more towards what your questioner is asking for.
There's one more question that just came up, if you want to take that, or we could do that at the next break.
Can I ask a question?
Yeah, go ahead.
I understand non-competes, but in the event of someone who's laid off, you didn't leave on your own accord to go to a competitor. How can it be legal to tell you where or where you cannot look for a job? After all, they initiated ending your employment. And if your skill set is such, shouldn't you be able to use it wherever you're able to get employed?
Right. So this is an important distinction. The enforceability of a non-compete provision doesn't depend on whether you walk away from the job or they fire you. It's enforceable on its terms if it's fair, regardless of the circumstances of your leaving. It's just a burden that's imposed on you as a condition of your employment. That's the deal. There's going to be usually, if it's a company of any size, don't solicit our customers, ever. Don't solicit for at least a period of years. Don't solicit our employees to come work for somebody else or encourage them to do it. Leave confidential information here and don't get a competing job for X years and Y miles. It's very complicated.
So you can't go.
I got to move on. Because our time is.
I was going to say you can't go to work for somebody in the same field then, you're saying.
Yeah, I'm sorry, I have to move on. Okay, I want to talk about the Paid Sick Leave Act because this is a change in the law within the last few years. Every employee, and I don't care if you're the only employee working for somebody or it's 10,000 employees, you accrue an hour of paid sick leave for every 30 hours you work. So if you work 1,200 hours, you get 40 hours of total paid sick leave per year. It's not able to be carried over. But if you accrued 40 hours and didn't use them in 2022, and you got very sick in 2023 in January, you can use the 40 hours from the previous year. You just don't get 40 more after that. So this is basically to fill in a gap that a lot of employers, especially small companies, just never get around to creating a sick leave policy. So this was a good thing. This is a benefit that the New Jersey legislature and Governor Murphy created for employees. I'm not going to cover that one. So here, we've already talked about covenants not to compete, also called non-compete agreement. They're enforceable if they're reasonable in duration and geography. There's also non-disclosure agreements. This became very prominent with the Harvey Weinstein and the Me Too experience over the last few years, where people, 15, 20, 25 people, are signing settlements with that person or his company, and then they're told, by the way, you can't talk about it. Well, how's the next person going to get warned if you can't talk about it? So the New Jersey legislature basically said, you know what? Those are not enforceable when it comes to sexual harassment and assault type behavior. You can talk all you want and it doesn't violate the agreement. Again, public policy coming to the rescue where the private sector and the power imbalance is shifted towards the employer and against the former employee. This is a generic statement. Title VII, the Americans with Disabilities Act, the Law Against Discrimination of New Jersey. These are all public policies that make it illegal, civilly illegal. It's not a criminal statute, but it's unlawful to discriminate in employment, whether it's about hiring, promotion, firing, based on 17 categories of experience of life. It's been around for probably 75 years, I believe. New Jersey is a great state from the point of view of against discrimination and giving people remedies for that. But what if you're an independent contractor, truly independent? You have more than a few clients and you have your own equipment. You make your own hours. That's how we tell whether somebody is employed versus independent contractor. Are you covered by non-discrimination? And the answer is that you can be. The question is, were you an independent contractor? Are you actually an employee? Yes or no? And there are certain things that you're still protected by as an employee that does not extend to an independent contractor, such as unemployment compensation, workers' compensation, right? That's one of the problems. If you're truly an employee but they misclassify you and you get hurt on the job, you have no workers' compensation, right? If they say we're not doing business with you anymore, you independent contractor, you don't get unemployment benefits. So again, this is a misclassification issue compounding the problem. The law against discrimination does not specifically govern 1099 people. It does not. We've added a mental health day slide. How do people get compensated for that? Is it a paid time off? Americans with Disabilities Act, which I really haven't talked about a lot here, there has to be reasonable accommodations for people. We just had a settlement in a case not long ago where everybody was working from home, but the company declared it's time for everybody to come back. And this one employee said to me, I have an anxiety disorder. This has so worked for me. I have a therapist who's saying I should stay home. And the question is whether the employer would allow her to do that. Ultimately, we negotiated with the employer. They did their investigation. They came back and said, we're extending for 12 months your ability to work from home. And then we'll talk again, which was great. I mean, it's not perfect, but it gave her the ability to do what she was doing well remotely. And, the employer did, I think, the right thing. I want to talk a little bit about a performance improvement plan. The symbol to the right is my basic feeling about that. I call this the death on wheels, image. When you're put on a plan like that, look for work elsewhere. it's very unlikely you're going to come through that with them saying you passed the test, keep your job. They're doing it to paper the file and say, sorry, it's been 60 days, 90 days, you haven't hit the metrics that we're asking of you, and so you're out. So termination of employment is important because it depends on whether you get unemployment insurance benefits. If you quit, you are not going to get them. If you decide you made a wrong decision and you should have stayed in there, the only thing you're going to be able to say is, I left, but that's because any reasonable employee would have left, that they mistreated me so badly. And there are cases like that. But my generic advice is, unless you absolutely, for health reasons, cannot stand another minute, stay in there until you're fired, because it guarantees you 6 months of unemployment benefits. I also want to say, somebody mentioned severance before. There are lots of cases where we get severance agreements to review. You should know your severance agreement in this state does not have any effect on whether you're eligible for unemployment benefits or vice versa. The two are really separate. As long as the severance in this jurisdiction is paying you to not come to work, right? If they say, we'll continue to pay you, but only if you put in 5 hours a week or 10 hours a week, then I don't think that unemployment would really give you that benefit back. So you have to really not be working there. Now, New York State does it differently. They say when your severance runs out, then you can first apply for unemployment. There's something called misconduct in the unemployment benefits arena. It could be relatively low level, modest, a rule violation. If they're persistent, if you're late every day, or there's something else, you tear something up on the job and you do it purposefully, kind of goes up in scale. You hit your boss with a golf club. The worse the conduct, the worse your chances of getting your benefits. So if it's a low level of misconduct, they might hit you for 4 weeks of non-payment. But you can get them at the end if you need a full 26 weeks and you're still not employed. You're just missing out on the first month or so. This is a bit of a repeat about severance agreements. There's no entitlement to severance pay. People think there is, and there isn't. Unless the employer, by a handbook provision or some contract, says, we will pay you, a week for every year. And most of them don't. Most of them, it's completely discretionary, and they're not going to tell you what the criteria are. So it's your negotiation. They'll hand you a document, say, review it. You have so many days to get it reviewed. If you're over 40, you have extra time to get it reviewed. At the end of the day, that's an agreement that you should bring to a lawyer just to go through it. There are things you can push back on, right? They say, you're releasing us from every manner of claim in the history of the world. You can at least say, and the employer is not making a claim against me. Or you will not disparage the employer in any way, shape, or form, including online. How about the employer won't do that either, and at least will give me a neutral reference. So this person worked from this date to that date. That might actually be helpful. If you're being fired and they're doing it for performance issues, you may not agree, but if they didn't like you, you don't want them giving a reference for you. So you can actually put those types of things into the agreement and say, that's an enforceable provision. And that's that. So Alex, you had a question. And you're next, so you have to go line up because otherwise they can't hear you.
Okay, and a practical question. Instantly, you're faced with a PIP and you are put on a performance improvement plan. What is the practical side at that point? Should Is this a time to see legal advice?
It certainly could be. It's not automatic. I mean, there are times that an employee will say, I haven't been doing a good job. I'm over my head. I was supposed to get support and I didn't get it. This is an important point for me to say. Employers are allowed to be wrong. They're allowed to be foolish, stupid, and a bunch of other things. There's no law against that, right? The only thing would be you can compete in the marketplace. If there's no non-compete, you can go work for their biggest competitor. But if they put you on a performance improvement, it could be because you're a whistleblower and you've made a valid complaint that they never investigated and now they want to push you out of the company. It could be that you've been discriminated against because you're a woman, because you're 70 and they're trying to weed out more senior workers. There's a host of reasons that people can misuse that tool. If it's one of those, yes, you're going to want to get legal information and advice because here's what I can do. I can reach back out to HR, to in-house counsel, to outside counsel, whatever the thing may be, and say, I have a client, Alex, who's very upset because he's been a great worker for 15 years and he's gotten the President's Award and a whole lot of other accolades. He gets letters from various people, what a great job he's doing. And all of a sudden, coincidentally, right after he complained about the nuclear fuel leak, they put him on a performance improvement plan. He knows more than everybody there, including his manager, right? We're going to get a negotiation there. We might get great severance there. This has happened. I had a medical doctor working for a major pharmaceutical company, and she was a whistleblower, and they acknowledged that she was a whistleblower. They had to protect her. I had a guy working for 16 years for a perfume company, was a scientist, did a great job for them. And all of a sudden, they put him on a performance improvement plan because he didn't get along with his boss. Now, that's not illegal, but I could at least say, you know what, he's raising his hand. He doesn't want to stay here any more than you want him to stay here. Can we work out a severance agreement? And you know what? A lot of times management is really happy to do that because they know they're not going to get sued.
Here is an interesting case, personal case. 30-some odd years ago, I was put on the PIP program for 30 days. At the end of the 30 days, in a staff meeting, the boss came to me in front of everybody and said, Alex, you made it. You are an asset to us. We are honored to have you. But I was smart. By then, I started looking. 3 months later, I resigned, and they said, no, you cannot leave. You're too valuable. So yes, sometimes it happens.
Right. That's, I would say that's on the order of finding a hen's tooth. It's rare. Somebody else told me of a PIP that was supposed to be silenced. I'm not going to say who that offender was. Somebody was put on a PIP by a pharmaceutical company in Central Jersey, and they made it through also because their boss said, listen, there's been a complaint against you that we have to investigate, and we have to look like we're taking it super seriously, but you don't have to worry about it. So that can happen too. These are all tools, that's all. They're tools in management's toolkit or in your toolkit, and it's all about negotiating. If there's something to negotiate, I can be helpful. I can tell you how to do it, or I can do it for you if you want me to. If your negotiating position is poor, doesn't matter if you have a lawyer or you don't. Chances are you're not going to get exactly what you're looking for. But if you try sometime, you just might find you get what you need. Yes, final question, because we're out of time.
Oh, I had a question about the unemployment. If you take a short-term assignment, like 4 months, established assignment, hopefully like a temp to perm kind of situation, and you're hired and you're in as an employee for those 4 months.
Yes.
But then it doesn't convert to permanent employment. Are you still eligible for unemployment? You You're an employee, so you're paying into the unemployment.
Okay, so look at bullet 1. If you've worked in our state a minimum of a quarter of the year, that's 3 months, and there's been wage withholding, then you get it.
Even if it's not a firing, it's just it was established in advance that you had a 4-month assignment, and then you just didn't become,
Yeah,
that's why I'm wondering.
yeah, I don't know. I could say this, I know teachers in certain points of their year, or say seasonal workers, they know there's an end point. We're gonna be picking this crop for 6 months, and then we're out.
And they get unemployment.
I believe they do.
I do.
Say that again.
I was in for a year working, and
Please, Bruce.
I was personally working for a year, and it was a known endpoint, and then I got unemployment. I'm collecting it now.
Good to know.
Yes, well, the unemployment system is very interesting. It's insurance, basically. So everybody pays in because some of us aren't going to stay in. And so it has its, tricks and turns and such like that. But if you have questions like that, let me know. I will find out if I don't know.
One more question.
It's close to the microphone, Bruce.
Oh, yeah.
This is the question after the last question. Go ahead.
COVID.
Yeah.
I'm associated with a small staff at a church, and somebody has proposed that we make it mandatory vaccination. That sounds like it's illegal now?
No, it's legal. As long as it's a fair request, like everybody's going to be tested. If you have a religious belief that says you can't do that. I think there's a case now that says in New Jersey, the appellate division recently said that may be a problem for the employer. But that's where maybe that person can work from home if it's possible to do that. The area of reasonable accommodation is very broad. Sometimes it's about disabilities. This is about a religious belief. So like if you are Orthodox Jewish, and you say, I don't want to work on a Saturday, but I'm willing to work on a Sunday or whatever, or I'll take less vacation time, there's a negotiation back and forth. And the employer has to show this is a hardship. It's not reasonable. I can't accommodate. So that's interesting because I don't know the full answer on that one. This is developing. In the heart of COVID, it was much more likely that was an enforceable demand. And even when the Supreme Court said that the federal government couldn't mandate it, it said nothing about the private sector. So if a large company said it and they say as a condition of employment, actually it wasn't that the federal government, it basically the presidential decree was that the federal government it was mandatory that they demand this. And in the private sector, you can't do that. What you can say is if the employer wants to do it, they can do it. So I think that's still the way things are. I don't think anything has changed about that.
Hanan, we have one online question that been patient. So.
All right.
If you voluntarily leave a job after 90 days due to misrepresentation of the job description, whereby the line authority was below your title, are you eligible to file for unemployment?
So I'm going to jump into a bit of a guess here. It sounds like some type of claim that the person misrepresented themselves, sort of the George Santos defense. It depends on how big it is. It depends.
I think the company was misrepresenting what his job was going to be as opposed to him.
Oh, I'm sorry. That's the part I missed. So what happened? They were let go because
They're voluntarily leaving after 90 days.
oh, they left because the job wasn't as advertised.
Right.
And they want to know if they get unemployment benefits?
Yeah.
Well, let's see. They meet the 3 months. I don't know. That's a good question. I would put, if they want to try it, it's not going to hurt. You're going to say, the employer misled me. You know, I don't know. But they quit, right? So they're saying, I quit, but any reasonable employee would have quit because the job was misrepresented. That's too close to call. I don't have a clear belief on that one at all. So we're stopping now. It was a pleasure meeting everybody and having this dialogue with all of you. I wish everybody well. You have my contact information available, and let me know if I could be of help. Thank you.
Thank you, Hanan. That was a very enlightening presentation, and thank you for providing the backup materials, because I think there's a lot buried in there that I think Hanan only scratched the surface. So I think that it was terrific. What resonated personally with me was the concept of the performance improvement plan. Been there, done that, and it was hard to work through, hard to understand. I wish I had known a little bit more than I did to try to keep my head above water. And it was funny, at that particular company, it didn't really work, and then I was out, I was collecting unemployment. And then 4 months later, I got a call from a peer manager of the guy who let me go saying, Bill, we need somebody just like you in this other department, kind of reporting up the same management chain, but working for me instead. So it had a happy ending, and I like that job a lot better. But you
have to repeat this question, but did the second guy know what had happened to you on the job?
Hanan just asked if the second guy knew what the first manager had let me go. Yes, he did. I think it was a big enough company that the third line manager didn't like me, and he approved all the first part of the process, but then the second hiring manager reported to a different third line manager, and he was fine, and the guy above them was also fine, so it was not an issue. But it's just what happens. Funny things happen in the corporate world.
Absolutely.
So anyway, that resonated with me. Thank you again. Coming up, there are a couple of other groups around that are cousin organizations of PSG of Mercer County, and that one of them is PSG of Central New Jersey. They are online at psgcnj.biz, and they meet Mondays at 10:30. There's also PSG of Morris County. psgmc.org is their address, and they meet Wednesdays at 9:30 a.m. Both of those meetings are virtual, as far as I understand, so you need to go to their website to register and learn about their meetings. Coming attractions here, next week, February 10th, our guest speaker will be Marianne Kennedy. Her topic is Learn Your Preference, using the Myers-Briggs indicator to focus your job search. Many of us have, I know myself, have found the Myers-Briggs survey and we've taken it, and then you read the paragraphs about what an INJT or whatever it is, but I think this will be a deeper dive into how to use it. So I think that's going to be a good session for everybody, and it's always good to know yourself in job search and help you find out what you want. February 17th, we have a special guest presenting, Bill Pagula. on developing your marketing plan. This is about taking a product marketing type approach into yourself as the product and looking at what you offer as well as who you might want to work for and how to get the word out there that you're available. So hope to see you here for that. If you can't make it here, we'll see you on GoToMeeting. But in any case, today I would like to, first of all, we're going after this meeting, as is customary, we'll be continuing the Zoom session, or I'm sorry, the GoToMeeting session for a while. And if you're online, feel free to hang out and enjoy the conversation with each other. After the meeting, though, I will end this session here in the library, and we will, people in the room here are invited to stay and talk and share experience and whatever else you do that falls under the major category of networking. So, so please stick around. You come and go as you please. And Hanan will be around for a little while. So today's show was produced by Alan Kirchner and Nora Walsh of the library. Executive producer is David Schuckman. And until next week, bye everybody.